Welcome to another episode of Subject to Interpretation. In celebration of the De la Moda Institute of Interpretation's 25th anniversary, in our Founders Series, we are interviewing interpreters, translators, and language access advocates who have had a hand in shaping the field as we know it. Today, we are joined by the remarkable Carla M. Mathers, Esquire. She's a seasoned attorney with over 2 decades of experience in Maryland and the District of Columbia. And not only is Carla a legal expert, but she's also a CHI, that's a certified hearing interpreter, a passionate advocate for language access and an influential figure in the field of interpretation as both an educator and a researcher. With a law degree from Howard University School of Law and an interpreting degree from the College of Southern Idaho, Carla's unique insights bridged the world of law and interpretation. She has served on various advisory committees and even authored a pivotal book called Sign Language Interpreters in Court: Understanding Best Practices, making her a leading voice in the intersection of ASL court interpreting, legal practice, and language access advocacy. With us today is also Margie English, a certified deaf interpreter. Now, those of you who are watching on YouTube will also see her on your screen, and in the background is Kelsey Mitchell, a certified hearing interpreter who will be the feed interpreter. Now, before we get any further, in prior conversations, Carla, you shared a motto with me used by deaf and other communities: nothing about us without us. So before we go on to today's interview, I'd like to first, of course, welcome you, welcome Margie, welcome Kelsey, and thank you for being here today. And I would like to talk about today's format, which is almost as important as the interview.
Thank you. And thanks for the kind words of introduction. Really, it's a thrill to be here, and it's a thrill to talk about the journey that I've gone through in this field that I'm passionate about, as you are about yours. You asked about today's format. Today, we're working through 2 interpreters in a relay type format that ought to be familiar to spoken language interpreters, because there are times when you work with languages of limited diffusion. So this is similar. The people who are watching on YouTube will see Margie. She's a specialized type of ASL interpreter called, as you mentioned, a certified deaf interpreter. We're going to abbreviate that for today's purposes to CDI. She can't hear, but I'll come back to that. She's getting her language, her source language input through a separate video monitor from Kelsey, who is an ASL interpreter who can hear. So if Margie were to interrupt for any reason to assert an interpreting process need for a repetition or a pause, you would hear her quote unquote voice through Kelsey speaking on the audio in the program. We use this configuration for a number of reasons, but most importantly is that American Sign Language is Margie's L1, but it's also her what I call primary daily use language, meaning that's how she receives and communicates every day, all day long, as opposed to me and some other interpreters who may actually have deaf parents, but they can hear, so they use English primarily as their daily language. We use that system because it's more accurate than simply through one interpreter. That's why we endorse it for the courts as well. We use what we fondly call CHI and CDI teams. It's a relay process, but it's far more common than languages of limited diffusion, or LLDs. when they're working in a relay interpreting pair. So we're seeing CDIs become normalized in many public-facing settings. That started, or at least it first came to my attention with FEMA, when we started having so many natural disasters like hurricanes and things. FEMA had a national effort to use deaf interpreters for media events. The White House on their YouTube channel has a full-time staff deaf interpreter interpreting all of President Biden's speeches and other major important events. And then during the pandemic, we saw a lot of it. Most of the governors' conferences, most of the really major televised events were interpreted on screen by a CDI with a hearing interpreter functioning just like Kelsey is in the background, listening to what is said and signing it to Margie. I'm sure we'll come back to information about CDIs, but I want to talk a little bit about the motto. You said nothing about us without us. That is used by not only members of the deaf community, but it's an old civil rights slogan or motto. And it essentially says, if you're going to talk about us, the group being talked about should be consulted and should make their own determinations about their life and about decisions or opinions about them. So we've discussed in separate conversations having a CDI on an upcoming broadcast for you so that you'll have an opportunity to delve deeper from the source and get their perspective as a CDI. So I hope that happens. I'm thrilled to hear that you're interested in doing that because, well, nothing about us without us, right?
Thank you, Carla, for that introduction. Much appreciated. Before we continue, I also would like you to just quickly bring attention to a couple of mechanics that have to do with the format that we're using today. One of them is that we have to be more paused and measured in how we speak and how we communicate so that the relay chain can, let's say, catch up. The second one is, and we all have I think, an interesting anecdote in that we've tried to record this podcast before, and we had some glitches because of the bandwidth that we were using on that particular day, which really made it impossible to communicate. So can we talk a little bit about those two mechanics, the pacing and the me, slowing down and the you waiting for the communication to really well and truly be completed. And also, the fact that we've got so much technology, but we really have to use it appropriately and advocate for the appropriate use of this technology in order to actually have it serve us.
Definitely. This is our second bite at the apple, and we're doing very well. In terms of the pacing, and you're doing far better at it than I am, but understanding that you have an English message put out in spoken English, Kelsey's hearing that, and then she's interpreting it to Margie in American Sign Language, I presume. And then Margie's working from that interpretation to your audience. So it does take longer, as you can imagine, when you're working with someone who uses a different language in a relay setting. It does take longer and it sounds somewhat abnormal, but that's because we're looking at this from a dominant cultural perspective, right? English is the working language of this country, which is, again, why I'm excited about your upcoming episode when English won't be the major language. It will be half of the language of the conversation will be English, in spoken English, and half will be in American Sign Language. And the viewers in the audience will experience what it's like to be subject to interpretation, if you will. The tech requirements are important. If you're going to work with any visual language like sign, with or without a CDI, you've got to make sure that you've got enough bandwidth so that the picture isn't choppy and degraded in any way. Fortunately, we have Margie, who works on video a lot, and she had the opportunity to test the system. And when it didn't work because of the Wi-Fi signal, we moved to a hardline, an Ethernet connection. So yeah, these are things we have to be cognizant of, just as you're cognizant of making sure the audio connection is good.
Now let's talk about a little bit about your background and career. You have a unique background as both an attorney and a CHI. It's a certified hearing interpreter, as opposed to certified healthcare interpreter for our friends who are
Right.
who are friends who are interpreters in the medical field in spoken languages, and your language in that realm is ASL. Can you describe your career journey and how you balance these two roles in your professional life?
Sure. Thank you. I've always been interested in language, and I've always been interested in the law. I'm a monolingual native English speaker, so being interested in language was hard. I wanted to be an interpreter from a very young age, but I knew I wanted to interpret in Spanish, but I didn't know Spanish. So the obstacles. My experience is similar to many other hearing interpreters who are adults. They are born as English speakers. They don't know sign language until their adult period, usually in college, like I did. And then they go on to become interpreters, which has interesting complications that we can talk about later for our field. I got certification as an interpreter and actually as a court interpreter before going to law school. I went, as you said, to Howard University. I went in 1990, and one of the really formative experiences for me happened before that. It happened in 1986. I was a sign language interpreter, and I went to a legal interpreter training at Montclair State College in New Jersey. And lots of people know about this training because there were 60 Spanish interpreters and 20 sign language interpreters. And we took our core training together. And we separated out for those periods of time when we were doing language specific activities. But it was truly a life-changing experience for me to realize that I could merge these two parts of myself, that I could do something with the law and do something with the language now that I knew another one. And so very shortly after that, I started investigating law school. And Howard was a wonderful, unique experience for me as a minority law student there. I saw so many parallels between the experience of the deaf community as what they consider themselves to be a language minority, not a handicapped or disabled group. And the experience of Black students that I went to school with. For example, I remember lots of students having the same experience of being the only or one of a very few Black students who went to their undergraduate programs, UCLA or whatever their college program was. They were one of a very few. And then converging upon Howard University, where they're in the majority and they have power, was transformative. The same I've seen with deaf people who maybe in their high school years, maybe one of a small number, sometimes just one deaf person within an entire milieu of hearing students in high school. And then a lucky few of them get to converge on Gallaudet University, which is the world's only liberal arts university for the deaf in Washington, in which they are a majority, and it's an empowering experience and transformative again. So I see so many parallels that I really appreciated my time at Howard. I was fortunate and privileged to be there. And I just always appreciate the history that I saw while I was there. So after law school, I litigated at a law firm for 15, 20 years. And then I did about 10 years at different deaf-related organizations. One was a deaf-run organization, one was an interpreting service, and I was what's called general counsel. They also call it in-house counsel, but it's essentially you're a jack of all trades, and when you're there to identify problems and send them out when you need a specialist. And then to bring this all back full circle, in about 2017, I stopped practicing law. My spouse had retired, and I went back to interpreting just in court and teaching court interpreters. So while I maintain my law license, I no longer practice, but I'm still in the field, just like I wanted to be when I was like 7 years old.
Now, the jobs that you had, the law firm, and especially the two jobs that came after the law firm, have been related to language access, haven't they? It seems that you have you really, have married your interest in advocacy with and been able to practice that while you have been, practicing law in this field. Can you talk a little bit about that?
Sure. At the law firm, I joined a firm of one of my professors at Howard University. We're a very small firm, did just primarily general practice, but I had deaf clients so that I was able to work with the community and interface with the community through my clients. The firm itself had a focus on discrimination, anti-discrimination work, and a huge number of church clients. My deaf clientele was everything: divorce, criminal defense work, property law, family law, and some portion of discrimination work. One of the fondest cases I had, although it was a struggle, was a national class action that we sued the post office on behalf of deaf employees for not providing interpreters. And so we did some discrimination work, but the majority of the clients could hear because that's the demographics. And I worked in a firm, and so I worked with hearing clients most of the time, but also a fair number of deaf clients. My first in-house counsel position was with we call them VRS, Video Relay Service company. So it was essentially a telecommunications company that made the telephone accessible to deaf people by providing interpreting services over video, which looks very much like what we're doing right now. But what we're doing right now is called video remote interpreting. So VRS is a federally funded telephone service for the deaf. So the kinds of law I did were more administrative law, dealing with the FCC and doing filings. And then there was a fair amount of business law because there were competitors, and some intellectual property law, and employment law because we had employees. And most of the administrative employees there were deaf. And then they had a whole service full of interpreters too, who worked at their call center. After that, I worked for about, I think, 7 years in an interpreting service. They didn't really need an attorney, but they wanted me and I wanted them, and they let me teach through their program. but essentially I functioned as their HR department. So it did a lot of administrative, a lot of employment related things and contracts and again, they gave me the opportunity to teach. What else was I going to say about that? Those are pretty much the three legal related jobs that I've had and how they relate to. I mean, I've always taught, even throughout those. I didn't interpret during the time that I was practicing law, exclusively practicing law, but I did manage to retain my hand by teaching. And it wasn't until 2017 that I was able to do more of that.
I would imagine that with your legal background, this would enhance your ability to teach students, especially understanding issues, not just of language access, but of, issues that are related to civil rights, the ADA, and services in general, as you mentioned earlier, the VSR, right?
Right. Well, I hope so. I do. We certainly need more legal interpreters. We need more qualified legal interpreters. So I don't think I dumb down things for them, and I do hope that people benefit from the legal part of my background as well as the interpreting part.
You mentioned earlier when we were talking about our esteemed CDI, Margie, that her L1 is, let's talk about that.
Sure.
The languages, L1 meaning primary language, L2 secondary language, are different in how they're understood in the deaf community as opposed to the spoken language community. Could you talk a little bit more about that?
It goes back to the idea of having a native language and having a primary language, or the primary language that you use. Obviously, the native language is the one that you were born into. Margie is unique because she's born into a family that they were all deaf. So her native language and her primary language are American Sign Language. Now, most interpreters are like me, who are born into a family of English users and then learn ASL later in life. There are a subset of interpreters like me who can hear, who also have deaf parents, and their L1s would be then whatever sign language their parents used. They're called codas. You might have heard that term from the Academy Award winning movie last year, the year before last. But so they're a subset. Most deaf people are not like Margie. Most deaf people are born to parents who can hear. And so when Margie was born, I hate to use you as an example, I'm so sorry, but she had language access from the time she was born throughout. But most deaf people are born to parents who can hear. And those parents are somewhat traumatized by having what they believe is a broken or disabled child. So they spend some time working through that trauma. And their children don't have the same advantages as somebody like me who's born into a family that I share the language with. So their language is delayed, and that can cause issues. But this is not your question, I think. The point is that the earlier you have access to a full language, the more fluent you are later. And the amount of time that access to that language or language acquisition is delayed can cause problems later on. It's harder to become fluent. And so for me and most people like me, we had to work harder to become fluent in American Sign Language because we didn't have it early on. Most people become fluent because they're native and they're born into the language, or if they're second language learners, they, are immersed in it in some way. So you have to be exposed to fluent native users on an intensive basis and over long periods of time, because language changes. And so other languages, there are countries you can go to if you want to refresh your language, or if you want to become fluent, you can immerse yourself in the language and in the culture by visiting that community. We don't have that. So there's no country we can go to for that immersive experience. So when I'm learning, I might have deaf friends and I might become fluent, but then if I don't stay in contact with them, language stagnates. It becomes frozen. And as we know, native communities, natural users change because technology changes, users change, generational change causes language to be different. And so if you only learned it in school with your deaf friends, and then the only place you use it are in those work environments where you are, it's a real problem. And there's no country you can go to refresh and re-energize. So there is a problem with fluency in the field with people who are like me who can hear. And I don't want to imply that all people like me who can hear are inept language users. That's not the case. It just makes the addition of a deaf interpreter to the scene much more, it can guarantee a more accurate product for the courts. The best interpreters I know, often those with deaf parents, CODIS, are the very people advocating for the inclusion of a CDI on their team. We know that CDIs are more effective with people like me, but also in certain settings, in legal settings. Some settings just demand that higher level of accuracy. So I'm thinking mental health settings, or settings with deaf children, law enforcement settings, particularly custodial interviews, where the risk is so high that if you can bring in that additional layer of accuracy, you should always. And so standard practice comes from that, and now standard practice is to use CDIs in those high-risk settings. And additionally, the educational system, frankly, has made a mess of educating deaf children for so long, and the community has suffered it's now called language deprivation, because those early years where language learning is critical is missed. And so there's, and to use a word, handicap, there's a real obstacle to becoming fluent. The good thing is that leaders in the deaf community are really trying to wrangle back their educational system. But what it means is that for those of us working in the legal setting, there are these really complicated language dynamics of people coming out of school who aren't proficient in either English, and for deaf people that means reading English and writing English, or in signing American Sign Language. And so that's the third reason for me that deaf interpreters are critical in legal settings.
Now, before we move on to another subject, now you've mentioned a couple of times how using and working with deaf interpreters provides another level of accuracy. For us that we're not in this world, and it might be a little bit harder to understand why. What is the nuance? What is the difference? You may have already explained it to us, but it's still a little abstract for those of us who are from the spoken language world.
Sure. Again, there are the three settings I think that CDIs are indicated in. For me, a deaf interpreter is just far more accurate. They are attuned to visual nuance. And this is also a great question for your next episode, because I think a deaf interpreter knows what they do, but I can speak from what I know, what they do for me. When I am interpreting with a deaf interpreter, because ASL is my second language, and understand that ASL is my primary language at home. My spouse is deaf, and it has been for well over 20 years, but I still know that I will miss signs, I will miss intention, I will miss grammatical features. And I know that a CDI, at least the ones who are trained, it's a wide variety of skills and abilities, but aren't going to miss that because they use that language every day. So,
Carla, it's really critical, it seems to me, that we talk about training for interpreters, trainings for CHI, CDIs, training for the public, even people such as myself, a spoken language interpreter. You've done a lot of training, you've written a book, have done some research. Tell us a little bit about that. And maybe from there we can go on to talking about, training on a larger national scale with, certification schemes.
Certainly. First of all, legal research is different from academic research. I've done very little academic research, but a couple of things. As an attorney, I find academic research in the interpreting field to be not that helpful to attorneys, probably very helpful to interpreters, but for a number of reasons. Legal research is different. It's essentially finding precedent in a field and trying to figure out legal theory as it applies to court interpreting. So that's what my book was. Essentially, I took this foundations class, which I've been teaching for 30 years over different iterations. And I wrote down all of the case law, the statutory sites, the legislation, the policies, the practices, the ethics that my class was based on. I'd had too many people saying, well, we asked interpreters why they did that, and they said, well, because Carla said so. And that can't be the answer. I keep telling them, lawyers don't know who I am. A few interpreters do, but lawyers don't. So you need to be able to argue your position. So my idea for the book was to give them the legal authority that they could then use to research their own jurisdiction and make their own argument to get the working conditions that they need. The other legal research document that is my favorite is a document I did, a 50-state survey of all of the statutes related to CDIs and their use, when they are used, who decides, are they qualified, what are their qualifications, that kind of thing. And the document is called Deaf Interpreters and Accommodation is more than reasonable, because reasonable accommodation is an ADA term. And that's what they have to provide. And so I wanted to make a legal research document that argued why CDIs were reasonable accommodations. I did one academic paper that involved a video analysis of a deaf interpreter interpreting an attorney-client conference. That both of those, in fact, all of those documents are used in training, not only by me. But the video analysis was interesting because I used Cecilia Wadensko, Wadensjo, and I know I'm not pronouncing her name correctly. I used her model of interpreting as a triad, and interpreters who interact in some way and influence the mediated interaction in some way. So I analyzed the rate and the purpose and the function of deaf interpreters' interruptions to an attorney-client conference. I found that fascinating. And the last little bit of research, I just wrote a paper with two other brand new legal researcher court interpreters, one who's a CDI and one who's a CHI. And the goal of that paper was to introduce them to deaf and hearing teams for the internet generation, which was explained to me as being people with very short attention spans. So writing to that audience, for me, as writing legal research papers, was very, very challenging. But there is good news on the certification front, if you want me to talk about that. Sure. RAD, as you mentioned, and hello, Paul, if you're watching this, thank you for starting the conversation. RAD has a tortured history with certification, and particularly certification names. The legal certificate is called the Specialist Certificate Legal. And what that means is that we are tested, first of all, on a generalist level. Can we interpret in a variety of settings, but not legal? And once we hold that certification, then there are several, over the years, there have been several different specialty tests you can take. So ours was called the SCL. Started in the 70s, was revised in the 90s. If you're a psychometrician, that's a problem if your test is only revised once in 30 years. And in 2016, our board decided that it should be suspended. They called it sunsetted. And we haven't had a test since 2016. In a couple of years later, the RAD board set up a task force, which was both Margie and I were fortunate enough to be members of the legal task force regarding options to credentialing, and we came up with recommendations. We submitted those in 2022, and the board accepted them. And then the executive or the CEO said, wait, how much is this going to cost? Which is usually the question you get when you're talking about certification. So she did a financial analysis, and it was a really good analysis, but RAD is not in a position to pay for it. I don't think RAD solely ever paid for any of our legal tests. There was always some kind of federal grant that helped defray the costs. But state courts have been using our exam for 30 years, but they've never had to pay for it like they have to pay for their spoken language interpreter exams. So there is sort of a stakeholder group of people from the deaf community, from RAD, from the courts, who are now investigating how can we implement a test? How can we get one created like NCSC creates them for other languages? And that's where we are. I know that the RAD has presented to, I'm going to use an acronym and I'll spell it first, CLAC, which is CLAC. And that's the language professionals in the state court system have that organization. And they were given a presentation at their last conference, and they were very interested. And so there is an effort going, but the question and the bottom line is always, who's going to fund it and how much is it going to cost? And we're essentially pushing for the state courts to fund NCSC to develop our exam in collaboration with RAD, who are the specialists in our field, just like they do with every other spoken language that they test. So wish us luck.
Absolutely. Now, does that mean that the idea would be that each AOC or administrative office of the courts for each state would then not only oversee spoken language interpreters, but they would also oversee, I guess, the credentialing of sign language and CDI, CHIs within their states so that it can also then be, I guess, vetted. They can be vetted for those particular states?
I'm not entirely sure how the state courts their relationship between NCSC and administration and maintenance of the test, but in my mind, it should be done the same way. For all practical purposes, in the court that I work in most of the time, which is the Superior Court of the District of Columbia, certainly one office manages all languages, including sign language. But I don't know how they run their or administer the testing part of it.
Well, certainly there will be, it's important for different states to start looking into that. I can speak from experience here in Georgia, and also you mentioned Paul earlier. That's Paul Panuski, Panuskyi, who is a colleague here in Georgia and an attorney and SEL. And we have been working with the Georgia Committee on Interpreters on bringing the sign languages interpreters into the fold, and so that they're not kind of hanging out there on a branch, and that we can provide support for those interpreters. So sign language interpreters and spoken language interpreters will begin to receive Georgia orientation training together in the coming year. Which makes a lot of sense to me, because we do share a lot of professional goals, and there's lots of things that we can learn from each other.
Agreed. Definitely. That's great news. Congratulations. That would be a wonderful opportunity for all interpreters to learn from each other in Georgia.
Now, one of the things that I learned earlier on was that, for example, spoken language interpreters are, I guess their reason for existing is based on, Title VI of the Civil Rights Act, and obviously a number of other legislation, such as the Court Interpreters Act of 1978. And other things like that. But of course, the backbone of sign language interpreting, or interpreting for the deaf population, comes from the American with Disabilities Act, the ADA, from 1990. Can you give us a little bit of a summary, perhaps, of what changes you have seen since the inception of this, and whether where you think we need to go next, so that we go beyond just basic reasonable accommodations, as you mentioned earlier?
Sure. So just for clarification, the deaf community has had legal protection, even before the ADA, but it wasn't consistent. And so the major benefit that the ADA brought us was more consistency. So for example, one of the cases that established not a constitutional right to an interpreter, but the right to interpreter being constitutionally mandated, was Negron, and that's Negron. Right. So Negron applied in criminal cases only, and it implemented the Sixth Amendment, but it essentially had been interpreted to include sign language interpreting as well. We also had, beginning in 1973, what we lovingly call Section 504. Basically, 504 said if you receive federal financial assistance, you have to make your programs and services accessible to the deaf community. But, there was still a fight. Courts said, we don't receive federal financial assistance, so you still don't get interpreters in civil cases. And it was a fight. So that didn't really go. We also had, it didn't go away until the ADA. But we also had a fair number of state interpreting statutes that provided healthy protection. And ours were quite broad, ours meaning for the deaf community. So broad to the extent that they included the judicial system, the executive branch, the legislative branch. So deaf people could ask for an interpreter to go to a hearing in their, as in whatever state they were in that had that statute. And they also singled out law enforcement interpreting for the most part. So those were good protections, but again, they were limited. The ADA was very broad in that it applied to, it had a whole section on employers and about not discriminating. It had a whole section about the state and local governments not discriminating. And then it had the public accommodations section, which applied to hospitals, doctors' offices, lawyers' offices, movie theaters. And so it really opened a whole world of opportunity that wasn't there before. The final part of it was Title IV, and that, Title IV. And it said that the telephone system has to be equally accessible to deaf people. And that's where this provision of video relay service came in through Title IV of the ADA. So really the world changed with that. There's a problem with using VRS, particularly in the legal system, because the interpreters, you don't know their qualifications. And we know that it takes specialized training to work in legal settings, but lawyers under Title III should provide interpreters, but under Title IV, the FCC pays for them if I just make it a phone call instead of an office visit. And so there's VRS services have been problematic for us for a while. Gosh, there are so many things that I would like to see happen next, not necessarily on the legislative front, but certainly I'd like to see more language justice than just language access. I'd like to see consistency in services so that an attorney has communicative services with his client other than VRS before and out in the hallway. And, depending on where you are, sometimes the court interpreter will do those and sometimes they won't. There's no consistency. I'd like to see deaf people have access to programs post determination, so parenting classes, and a lot of times, at least in my courts, those interpreters are provided for those, but that's not uniform throughout the country. I'd like to see and I hope in your next episode you can talk more about this too, but to have the first contact of a deaf person with the court system be assessed by a deaf interpreter to determine the actual language needs. I've seen that make a huge difference, and I've also seen it where a deaf interpreter wasn't provided initially, and when they were provided, things got better, but for the court, it was confusing because why was this not needed all the way up until now? So there's a number of things I would do if I was in charge. And those are just a few of them.
Well, there is so much that we could go into, and I just feel like we have barely even scratched the surface on all of this. I'm wondering if you have any parting thoughts for us, knowing that we will work together to do a follow-up episode. of this podcast, and to, go deeper into a lot of these important topics.
Thank you. And I'm excited for that opportunity too. I just wanted to give, because I haven't done this yet, but I wanted to give a little bit of background about my relationship with De La Mora. I met your founder in 2007 when I joined their team to start teaching for Pennsylvania state court system. And I have had the opportunity to teach with them every year since. It's been so enlightening. I learned so much about what your field does, and I hope that was mutual. I think it was. There's a lot of respect there, and it's, again, I teach for De La Mora in their virtual programs. I love in-person teaching. I hope that never goes away, but I understand the value and the comfort and the ease of online. But I've always said that De La Mora was like the only spoken language interpreter company that I would consider getting involved with, because I knew them personally, and I know that they live the values. And so I just wanted to make sure that I had an opportunity to put that little, it's not a plug because I'm not plugging anything. I just want to know, I want you to know I have a relationship with your organization that goes way back.
Well, we definitely appreciate you and appreciate what you do and what you bring to De La Mora. And in particular, for example, just the idea when we started talking about doing this interview, you wanted to make it a lot more than just a spoken interview with you. You really wanted to help us, to help me get a sense of, your world, the world of, sign language, of deaf interpreting. And often as spoken language interpreters, we have our own frustrations that we have. But it's really good for us to put ourselves and to see the other side, and also learn to adjust and adapt. So this has been a wonderful opportunity for me, and I'm hoping for our viewers and even our listeners who have heard a different episode and now are hearing this one and are wondering why we've had to make the adjustments and the adaptations that we have to make this accessible, and make it more than accessible, to make it participatory.
I could not have said that better. Thank you so much.
Carla, thank you very much. I know that we are going to we're going to come back and we'll have more on this, and I'm certainly looking forward to learning more from your colleagues and yourself. We're going to wrap it up for now, because I'm sure that our friend Margie and our friend Kelsey are starting to get a little tired. We've worked them hard, but we are so grateful that you are here, both of you, Margie and Kelsey. Thank you so much for being here, helping us, spread some more awareness about things that maybe many of us take for granted. Thank you, all of you.
Thank you.
And for those of you who are listening and watching this episode of Subject to Interpretation, thank you for being part of our most inclusive podcast episode to date. We hope to be able to continue on this journey with you. And don't forget to leave your comments for us or email us at podcast@delamorainstitute.com. That will be also appearing on the screen for you. Thank you very, very much for joining us, and never stop learning.